of the Court of Appeals, which reversed the Court of Appeals decision written by Justice Louis Ceci, goes into this entire matter of a confession that takes place within a period of time after an unlawful or illegal search. The part that is clear and that is most important here is page 7 in the slip opinion that I have. The court said the defendant was given Miranda warnings and signed a waiver of constitutional rights for him prior to his statement. These facts weigh in favor of finding that the statement and resulting search were voluntarily and sufficiently attenuated from the illegal searches. However, the presence of Miranda warnings alone does not cause a statement to be sufficiently attenuated so as to purge it of the taint of the illegal action, citing Brown 422 U.S. at 603. There are other factors that must be considered in determining the question of attenuation. These are the temporal proximity of the official misconduct in the confession, the presence of intervening circumstances, and the purpose and flagrancy of the official misconduct. The court goes on then to analyze, and I submit to you that taking all of the facts that one could conjure up to make an argument to stop this confession from coming in, clearly under Anderson, the confession would come in. So therefore, that is a most recent enlightenment from our Supreme Court telling us that our attempts to make any such argument in this court would be entirely frivolous, in my opinion. I would also like to say that our defense team has done everything possible to put a lid on the horrific aspect of this case. I am most impressed with the conduct of the District Attorney's Office and the Police Department in doing the same thing. The memories of these very unfortunate victims need not be subjected to descriptions of conduct that is, to say the least, incredibly revolting. I could not be a party to a parade of physical evidence being brought into a courtroom because of a futile motion to suppress, when the obvious outcome of that would be nothing more than to create a horror story of infinite proportion. Such would only be done if it were necessary. It should never be done just so a lawyer won't have to worry about the criticism for his decision. I will accept such criticism, but I can't believe any responsible lawyer sitting in my shoes would do anything other than what I am doing here. The families of these poor victims have suffered enough. This community has been likewise embarrassed because this unfortunate tragedy has taken place in the city. It is time for the right decisions to be made, and I accept the responsibility for making them. I wish to advise the court that this matter will proceed only on the insanity proposition. We will be prepared to start on the 27th. Some discussions about procedure will have to take place between the court, Mr. McCann and his staff, and of course myself and my staff, but I am sure there will be relatively few, if any, problems in arriving at a proper way of proceeding. I wish to address the one remaining motion, but I shall do so without memorializing my thoughts on paper. The reason is that as I write this the night before the hearing, I have decided that this motion can be argued orally without it being first written. As I have decided to have this statement reproduced in order to save myself from having to paraphrase it when this hearing ends, when we shall be besieged with questions by the press, I felt that since the last motion is quite simple, I should discuss that orally and not reduce my thoughts to writing. Your Honor, I apologize for the length of this statement, but I have thought long and hard about the necessity to do so. I feel that this is probably the most major case in the history of the state. Pray that no such type of situation may ever come again. I'm told there are 50 media entities present here today. I'm told there are in excess of 6 million viewers of Court TV which may be watching these proceedings. I'm told that the local TV media is carrying the matter live and that national TV is likewise broadcasting it. I have received countless media requests this last week. I have told everyone that I will say nothing until I speak to Your Honor in court today. But in fairness to the media and to the public at large, I have reproduced this statement for the media's perusal to hopefully assist them in recounting to the public what is happening in this case, so there are no false impressions as to the reasons for the decisions that have been made by Mr. Dahmer and myself. I have made copies of these remarks available to the press. Your Honor, I would like now, if the court would, to ask Mr. Dahmer if everything that I have said in here today is substantially true and correct. And I would also like to tell the court a couple of other things, that Dr. Ken Smale was with my associate Ellen Ryan and Mr. Dahmer on Friday as the guilty plea questionnaires were being gone over. He is of the opinion, and he can express it on the record, that Mr. Dahmer was indeed competent to understand the nature of the proceedings against him and to assist us in his own defense, that he was competent to waive the rights that he has waived, that he is presently competent in this courtroom as he sits here today. And I would like you, and I would also like to tell the court that this statement was gone over with by Mr. Dahmer, and he has given me authorization to make all of the statements that I made in here for the purposes of crystallizing the issue, and the only issue in this case, and that is what his mental responsibility was at the time of the commission of the offense. So I'd ask the court to make inquiry as to whether those things that I've said and those things that I've attributed to Mr. Dahmer are true and correct, both to satisfy the court and the district attorney and for the purpose of the record, not in any way to help me have some kind of corroboration of what I've said. As I said, I will accept everything that I've done because I know that what I have done is done in the proper aims of the criminal justice system. With that in mind, and after the court makes whatever inquiries it wishes to make and whether it decides it wants to take these pleas this morning, which is entirely up to the court, I would then be prepared to argue the only remaining matter before the court, which is the continuation of the discussion on the motion for the change of place of trial. Thank you, Your Honor.
Okay, I think we should first deal with the withdrawal of these motions.
Yes, sir.
Secondly, we should go on to the matter of the taking of the pleas. And thirdly, we should then discuss the remaining motion, which has to do with the conduct of the trial itself, which takes place on the 27th. So, for Mr. Dahmer, you've heard your attorney address the court.
Yes,
do you feel that you have understood everything that he has said?
yes, Your Honor.
Do you agree with what he has said?
Yes, I do.
Now, he's asked to withdraw two motions to suppress. One to suppress physical evidence, the other to suppress statements. Are you satisfied that he's fully advised you as to your rights in regard to those motions?
Yes, he has, Your Honor.
And understanding those rights, is it your desire that those motions be withdrawn?
Yes, it is.
Mr. McCann, do you have anything you want to add at this point?
No, I do not, Your Honor. I assume the court will inquire as to whether threats or promises have been made and so on.
Anybody made any threats or promises to you in regard to this?
No, they haven't, Your Honor.
You're doing this, is that correct, that you're doing this of your own free will?
Yes, I'm doing this voluntarily.
Court will allow the motions to be withdrawn. The next matter is the matter of the guilty pleas, and it is my understanding, sir, from what your attorney has told me, that you desire to change your plea of not guilty to guilty as to each and every one of the various counts in the information. Is that correct?
That's correct, Your Honor.
And it is the understanding, of course, that the plea of not guilty by reason of mental disease or defect remains. You understand that, sir?
Yes, I do.
Okay. Now, Mr. Boyle, this is undoubtedly repetitious, but just so we have our record together, let me inquire of you. Have you indeed advised your client of the elements of each and every one of these offenses?
I have, as have my two associates, Your Honor.
Okay. Mr. Dahmer, has your lawyer told you what the state would have to prove in order to establish your guilt? Sir, I have to have a verbal response.
Yes.
Okay. Let me explain that we have a young lady here that's taking everything down that's being said. We have to have this all in a verbal manner so that other lawyers and other judges can review what we're doing here today. Now, sir, as a part of that, did he explain to you that there are certain parts or elements of the offense that have to be proven?
Yes, he did.
Now, I believe Mr. Boyle told me that he went over the jury instructions with you. Is that correct?
That's right, Your Honor.
Are you satisfied that you fully understand all of these things?
Yes, I do.
Court then finds that the defendant understands the nature of the offenses that he is charged with. Now, sir, as to each count, your lawyer has prepared a form that we call a guilty plea questionnaire and waiver of rights form. Have you gone over each and every one of those forms with one or more of your lawyers? Mr. Boyle, have you yourself gone over each one of these with him?
I have gone over the guilty plea questionnaires with a guilty plea questionnaire and what it contains with Mr. Dahmer on 3 occasions. I then again went through the guilty plea questionnaire that was made out by Mr. Dahmer relative to count number 1, which is tabbed as 1 in the book that you have. As you can see on all 15 guilty plea questionnaires, at the beginning of each paragraph are the initials JD. I have certified with my discussion with Mr. Dahmer that in fact he did initial each and every paragraph of every one of the 15 guilty plea questionnaires in the presence of my associate Ellen Ryan. I asked him if he wanted me to reread the 15 guilty plea questionnaires and say the same thing 14 more times. He told me that would be a waste of time. His signature is on each and every guilty plea questionnaire, and I have discussed the elements of each and every one of these crimes with him, as have both of my associates, and he has signed the document saying that that has all been done. So I have, and Ellen Ryan, attorney working on this case, has gone over specifically each and every guilty plea questionnaire. In other words, she did it 15 times, and then Mr. Dahmer would initial each paragraph. And I asked Mr. Dahmer yesterday if that was a fact, and he said it was, but he did me the courtesy of not having to have me read each one of them 15 times. In other words, I've just been told by Ms. Ryan that while she read them to him, he then initialed them, but she didn't read the same thing 15 times, but the paragraph number 1 is the same 15 times, and they were then initialed by Mr. Dahmer, reflecting that he has read them and obviously has had them read to him by Ms. Ryan and by myself.
Okay. Then, sir, you have gone over each and every one of these forms with legal counsel, is that correct?
Yes, we have, Your Honor.
And do you feel you understand what they say?
I do understand.
And as to each of them, there's a signature at the bottom of the front page. Is that your signature, sir?
That's my signature.
And also on the back side, is that your signature, sir?
Yes, it is, Your Honor.
Has anybody promised you anything or threatened you in any way to get you to do this?
No, Your Honor.
Has your attorney advised you of the maximum penalties for these offenses?
Yes, he has.
Did he explain to you that as judge that I could impose up to those maximum penalties and in fact make the penalties consecutive if I thought it was the right thing to do?
Yes, he's done that.
Did he also discuss with you the law in Wisconsin as it exists today regarding parole date, which I guess it applies to 13 of them? Is that did Mr. Boyle explain that to you, sir?
Yes, he did.
You further understand, sir, that when you plead guilty to these offenses, there's a certain group of rights that you're giving up. You're giving up the right to remain silent, the right to confront the witnesses against you, the right to call witnesses on your own behalf, the right to a jury trial, and the right to require the state to prove each and every element of the offense charged beyond a reasonable doubt. Are you satisfied that you understand all of that, sir?
Yes, Your Honor.
Do you have any questions, sir?
No, I don't.
Mr. Boyle, have you had ample opportunity to go over all these matters with your client?
Without question, Your Honor.
The court then finds the plea is intelligently, freely, and voluntarily made. How do we wish to proceed as to the factual basis? We have stipulations in the material submitted.
Yes, to please the court, I understand basically the confession, the material gone over with Mr. Boyle would serve as the factual basis. On page 5 and page 6 of the statement that Mr. Boyle read, he touches upon some modest variances with respect to several counts between the information that has been acquired since the taking of the confessions and today. I know the variances to which he speaks. I do not think they create a problem, and I agree that that does not change the responsibility for the defendant with respect to those counts, and I don't see any purpose in going into what those variances might be. It is known to both the prosecution and the defense of that to which he speaks, and I don't think it alters the responsibility of the defendant. Under those circumstances, I see no problem with using as a factual basis the confession and the materials signed by Mr. Dahmer with counsel.
Mr. Dahmer, the materials that Mr. McCann has just referred to, are you satisfied you understand what all those materials are?
Yes, I do, Your Honor.
Do you agree that they're substantially true?
Yes.
Then based upon that statement by the defendant, the stipulation of counsel, the written materials that the court has in front of it, including signed statements from the defendant, based upon all of those materials as well as the pleas of guilty as to each and every one of the counts, the court will make a finding of guilty as to each and every one of the counts as contained in the information.
And of course, the court, I know, intends to include in that the amended complaint to which the defendant, that is part of this, the ultimate amended complaint,
Yes.
which is part of these documents.
Yes.
The entire amended complaint also serves as the basis. We did was we chopped it up and made it part of the individual.
Okay, let's make that clear. We have the entire amended complaint. We have the various statements that the defendant has made. We have the written statements that he has made that have been submitted to the court, and we have the stipulation of counsel as well as the pleas of guilty. Is that covered?
That covers it as far as I'm concerned.
Okay.
Yes, Your Honor.
That then is the basis of the court accepting the pleas. Now, Mr. Boyle, we have the other motion.
Well, I had filed a motion for a change in the place of trial. I think it was not necessary for me to carry in stacks of newspaper articles or magazines or tapes from television broadcasts because everyone in America, if not the world, knows of this case. Now, the reason that we have a motion for a change of the place of trial is because the locale in which the crime took place has been so oversaturated with information that in fairness to the right of fair trial by both the state and the defense, that we move it somewhere else, bring the jury from there back into the community where the crime took place and have the matter heard here. It is foolish for me to say that if we moved anywhere in the state of Wisconsin, we would find people when the court asked the question, do any of you know anything about this case, that they wouldn't raise their hand. How much they know basically is very limited because, as I have said, Mr. McCann and his office and the police department and the court have kept a very tight lid on all matters relating to this case. And I'm never worried about misinformation. I'm only worried about information that is that a jury knows about. So if a jury has information, it's misinformation, and we'll get rid of that no matter where we pick them from in very short order because they're going to hear the real facts at the start of the trial. Here's what troubles me about the matter being heard in Milwaukee County. Milwaukee County has an ancillary problem to the Dahmer case because of allegations that the police department didn't do its job relative to certain matters that were in existence during the time that Mr. Dahmer was committing these homicides. I don't really know how much of an issue that would be, and I can't really say that a jury might find a decision adverse to Mr. Dahmer because of that. I doubt it. And it's all going to come out anyway, whether the jury be from Milwaukee or the jury be from Rock County or La Crosse or Green Bay. But I have been reading in the last year or so how after a case is over with, a jury is beleaguered with the decision that they have made, regardless of what the decision is. In other words, they make their decision, they go back into the community, and suddenly they become, some wrath is taken out on the jurors for making the decision they made. It happened in a Hinckley case. It happened in a case just in New York involving the Jewish preacher that was killed. There was a claim that they were going to march on the jurors' homes. I just think that very unfair. I think that takes it gives to a local jury and maybe a further undue burden, and it concerns me. They wouldn't be able to go back into the community and stay and be in any way antiseptic from their decision. But I don't know if that's a basis for moving it. I think it is, and I think the court should use its discretion and allow us to get a jury from out of this community who can make this decision without any concern other than the absolute facts presented in the courtroom. Now, we can get around that by making the inquiry when we go through the process of voir dire, but the problem is when we ask the question, we're highlighting the problem. In other words, for us to ask potential jurors, are you going to be in any way concerned about your neighbors picketing your house if you make X, Y, and Z decision, we're suddenly telling them something that maybe we shouldn't even have to bother telling them about. And I think that the ancillary matters that have taken place relative to these questions about the police department and what it's done and what it didn't do is sufficient for this court to use its discretion to say, let's go out and get a jury, the best possible jury you can find, who would have the least amount of knowledge rather than the most amount of knowledge, so that the process of voir dire can take place in a faster way than otherwise anticipated, what with the kind of problems that I think occur here. I would also like to say, from personal experience years ago, I represented a police officer that was accused of a battery along with 2 other police officers, and the officer was acquitted. And there had been so much media attention to this case that 3 of the jurors called me after the fact, and they were telling me they were really running into a lot of problems because of the decisions they made. So I became somewhat sensitive to it, and that was 6 or 7 years ago. And I think that most of the time it's not a problem, but I think in a case of this sort, what with the question of Mr. Dahmer's sanity at the time of the commission of the offense, we should allow the 12 people, or one could take 12, I guess 11, to finalize the decision so that they can make the decision without any concern whatsoever that the people in the community where the crimes took place are in any way going to question the decision they make, whatever that decision is. I'm not suggesting a decision favorable to me or favorable to the state. It doesn't matter. And I think that because of that, and because of the ancillary problems that have been caused locally because of some alleged wrongdoing being attributed to certain members of the Milwaukee Police Department, I think the court could utilize its discretion and bring a jury in from out of the county. I have no other basis, Your Honor, to support any such change for the place of trial. Thank you.
Mr. McCann.
I've advised Mr. Boyle that I would not oppose that motion, and I would like to bring to the court's attention what I think are the basic criteria for the court to consider. They're spelled out in Jones versus State, 66, Wisconsin, 105, a 1974 case. And the 9 elements for the court to consider are as follows. 1, the inflammatory nature of the publicity concerning the crime. There was very extensive publicity in this community. There can be no doubt about it. There was extensive national publicity and international publicity. I think we had a crew here, I believe, at one of the presentations, one of the appearances from Tokyo. Persons who have traveled abroad have mentioned the case. So that there's no question there was very broad publicity. Inflammatory would be, in my opinion, publicity calling for immediate or action of a oppressive nature on the defendant and so on. And I do not recall seeing that type of publicity, the rabble-rousing type that lends itself to inflammation. Secondly, the degree to which adverse publicity permeated the area from which the jury panel would be drawn. There's no doubt in my mind that the adverse publicity permeated the area. The particular points are raised at 109, page 109 of that report. And I'm reading those 9 elements from page 109, 66, Wisconsin 2nd. And there can be no doubt that adverse publicity, meaning publicity that certainly was not supportive of the defendant, did permeate the area. Third, the timing and specificity of the publicity. I think this is important because there was immense amounts when the case first broke. However, that has substantially abated, I think in good part because of the responsible manner in which counsel for the state and the defense and the police department handled inquiries from the press. There was a steady drumbeat of inquiries, requests for appearances, comments, and so on that I know I turned down. I suspect that it was even more intense to Mr. Boyle that he turned down, and to the police. The police, very responsibly, as further information was developed. We all know, all of the participants in this matter are familiar with how the press operates, and all of us know that by feeding bits as the investigation progressed, bits of information, a steady on-beat of intense publicity could have been maintained. Due to the professionalism of all participants, the police, the persons in Mr. Boyle's office and our office, that did not happen. And there was not an intense ongoing beat of publicity. Fourth, the degree of care exercised, which I think relates to the media. Later comments and reading of the other case suggest that, and I think the media in terms of not been outlandish, I think with respect to one individual that I think made some outlandish claims on national TV, several appearances. I think otherwise basically outlandish claims were not a part of this, and there was basically degree of care exercised was there by the media. Fifth, the amount of difficulty encountered in selecting the jury, and I think this is very important, and that is if the court rules against the motion and does proceed with the selection of a jury here, I think the court has to hold that as an open question. In other words, if we find out that there is great difficulty in selecting a jury, I think the court should hold, if the court's decision is to do it here, you've got to hold it open. And I know that there have been substantial plans made here by the media to cover this and so on. That wouldn't be affected by going to a different county to select the jury and then returning here to proceed with that. The court has unequivocally stated that the trial will be in this courtroom. I understand that. But of course the motion is directed simply to traveling to a different county, selecting the jury in that county, and then returning here. So that I think that item number 6, the extent, the amount of difficulty, number 5, the amount of difficulty encountered in selecting the jury, that has to be held in abatement, would be experienced only if the court decides at least to provisionally proceed with the jury from this county. 6, the extent to which jurors were familiar with the publicity. There will be, I think probably almost anywhere we go, there will be some degree of familiarity. Realistically, I think that degree of familiarity will be most heavy in this county. I think that's a realistic appraisal. 7th, the defendant's utilization of challenges, both peremptory and for cause, available to him on voir dire. And that's something, again, that it looks to the future. That's something that the motions may be brought by the defense more than usual, I think, in a case, and that's something that the judge, you as the court, would have to decide at that time. 8th, the participation of the state in the adverse publicity. And I think the fact is that we have not participated in the creation of publicity. I think Mr. Boyle was sensitive to this from the beginning, so was I, so have the police, and I think the state has not participated in the creation of adverse publicity, or indeed any publicity. You could strike that down, other than the initial statements about the case that are fully compatible with the ethical guidelines spelled out in the Supreme Court rules. Indeed, repeatedly, I would say to the press, as I am required to do so, reminded that there is a presumption of innocence, even though the defendant has been charged. Although that usually was excised, always excised by the print media, never printed by the print media, did, I believe, come across a number of times in the TV media. 9, the severity of the offenses charged and the nature of the verdict returned. In terms of the severity of the offense charged, obviously there could be no more severe charges. In the history of the state, there's been no greater number of charges brought. So in terms of the 9th element, obviously, we're talking about maximum. Because for the very serious reason I do not wish to have to retry this case, a very practical, mundane consideration, as well as any interest of justice that may be involved here, I'm going to join with the defendant's motion for a change of venue, appreciating at the same time that if the court decides otherwise, that the court will, I assume, continue to consider measurably, particularly those points under the 9 that I spelled out, that is sub 5 and sub 6 and sub 7, which were reserved really those considerations for the court, if the court proceeds with a local jury, for the court to continue to be sensitive to the potential of problems with the jury and to say, sorry, we've started here, we're not going to do it here, we're going to move to another venue and select the jury. I don't think that raises any questions of jeopardy. Double jeopardy, we're all fully familiar with the rule. The double jeopardy vests only when the jurors are sworn to hear the evidence after the selection process. So clearly, if the court decides to start with a selection process here, then determines that indeed the problems cannot be met, that would not create problems of double jeopardy. So with that, that closes our comment in response to the motion for change of venue.
I have nothing further to say relative to the question.
The court has given a great deal of thought to this matter. Among other things, we have asked each council to submit suggestions as to possible counties in which to select jurors. We have inquired of those counties. We have also inquired of other counties. And first of all, let me tell you that nobody is really very anxious to see us come. That's one of the considerations. Substantial preparations have been made in this county for the handling of this trial, both in terms of some of the physical things which everybody can see in the courtroom, as well as such matters as preparations for calling in jurors. I think it would present some additional problems were it necessary for us physically to select jurors at another location, another courtroom, another seating arrangement. There's a great deal of difficulty. I've even considered the possibility of selecting the jurors here, but bringing in jurors from another county for the jury selection process itself. One of the things that I have to look at is what are the issues going to be in this trial? Because that's going to have a lot to do with the ability to select a fair and impartial jury. Guilt or innocence is no longer an issue in this case. What is an issue in this case is whether or not